All right, Senator Leno, you're up. It's a good bill, but it's not the end. It's not the. We need to. All right. We are on file item 8, which is SB 1150. After that, I have a bill up, and then we will be done. For anyone who's thinking about dinner plans. All right. There is, let's see, this is a bill without any amendments.
Actually, there is a recommended amendment concerning multiple successors in the analysis, and I would like to take
all right, very good.
an author's amendment.
Excellent.
And thank the staff for that suggestion, as well as for the very thoughtful analysis. And the bill before us today will very simply extend some clarity to mortgage servicers and some common sense protections to surviving homeowners upon the death of a spouse or a loved one who is named on the mortgage note. Many of us were here for the many-year debate, which resulted in a package of bills known as the Homeowner Bill of Rights. I think we passed that in 2012. And many of the issues arose through the foreclosure crisis around the time of the crash of 2008. And if you remember back, it was really at epidemic proportions. My piece of effort in the Homeowner Bill of Rights had to do with the dual tracking that was ongoing. And that was a practice of driving owners to foreclosure even while they were working with their servicer on loan modification. So one arm was working on loan modification, the other was sending the sheriff to knock on your door to tell you you've been foreclosed upon. So that was put to an end, and through requirements of communication that before foreclosure can begin, certain things have to take place. Also, the Homeowner Bill of Rights provided a single point of contact. So if you are in need of loan modification or other situations which would require you to contact your servicer, you don't pick up the phone, wait 3-4 hours to get through, and then have to start your story over every time with a new person. This Homeowner Bill of Rights requires a single point of contact. So years later, we have come to learn that the Homeowner Bill of Rights has been very effective in, and I want to underscore this because it's really the goal of this bill as well, preventing unnecessary foreclosures. We know there will, as sad as it is for anyone to find him or herself in foreclosure, there will be. Circumstances change. But where we can prevent unnecessary foreclosures, we will be serving our constituents successfully. And the Homeowner Bill of Rights has done that for many, many families. And stabilized neighborhoods, keep in mind when there is a foreclosure, it depresses the home prices and only exacerbates the phenomenon of many being underwater. What we didn't imagine when we passed the Homeowner Bill of Rights is that many of these protections and obligations that we passed to homeowners didn't benefit their surviving spouses and other loved ones who inherit the property when they die. So you will hear from some of the counselors who work with these folks, and that's just a small portion because all those who need attention and assistance don't know that there are counselors or don't know how to find their way to a counselor. Ongoing heartbreaking stories. In the first policy committee, in the banking committee, we heard from a man who had inherited the property from his wife, and it took him literally years to finally make contact with the servicer, finally be able to have it determined that, yes, he is the homeowner. The property was passed to him through the will of his wife, and that at certain points he was hearing from his lender we'll only talk to your deceased spouse. Literally, put that in writing. We'll only talk to your deceased spouse. Had heard many people come and stand in line, and you won't hear from them today because after this long hearing, they've had to go home, that the request for the death certificate to determine, in fact, that the person whose name is on the mortgage had died, not once, twice, 3 times, 25 times, and of course the trauma of the loss of having that loved one die revisited every time. It almost sounds like torture. So this bill will extend the reasonable communication requirements and legal protections to surviving homeowners, and those I use that term as those who have an ownership interest, but are not on the mortgage note. So specifically, the bill, upon the death of the mortgage holder, a surviving homeowner with ownership interest will be obliged to inform the lender of the death. So that's, if I'm the surviving homeowner, that's my responsibility. I then also must provide proof of the death and documentation establishing their identity, my identity, and ownership interest in the home. Once the documents are received, the surviving homeowner will hold the status of successor in interest. So, person has responsibilities resulting in successor of interest. The lender will then have the responsibility to provide a single point of contact and accurate information about the loan and the successor's options, including loan assumption and foreclosure avoidance programs. This bill does not provide a successor with any loan options that are not already allowed by the terms of the original loan. And I think that's worth repeating. This bill does not provide a successor with any loan options that are not already allowed by the terms of the original loan. If the mortgage is assumable, under the terms of the contract and the applicable laws and regulations, the servicer must allow the successor in interest to assume it. But that, again, is if it's assumable under the terms of the original contract. The successor of interest also must be allowed to pursue any foreclosure avoidance programs that are allowable. The bill does not guarantee a loan modification or any other outcome, but gives the successor in interest a fair chance to save their home. Again, we're trying to prevent avoidable foreclosures. It's important to note that many of these requirements already apply to servicers who handle Fannie Mae, Freddie Mac, FHA, and VA loans. And they've been, those requirements, in place for years. So servicers should find it relatively easy to extend them to all loans. I think if you add up Fannie Mae, Freddie Mac, FHA, and VA, we're talking about well over 65% of all mortgages already. If a foreclosure process is begun in violation of these reasonable requirements, a limited private right of action modeled after the Homeowner Bill of Rights would be available for the successor in interest. And again, for anyone who would suggest that that's onerous to have this limited private right of action, if it's been brought against you, all you have to do is do what you had to do before the private right of action was brought. Just do what you're required to do. Private right of action goes away. This private right of action is exceedingly important because it's an appropriate remedy. It allows a homeowner to halt a foreclosure so that the violation can be corrected. There's no other way to stop it, and that's what we're trying to do, if it's possible, stop that unnecessary foreclosure. So the bill has broad support from our Attorney General Kamala Harris to the California District Attorneys Association, the AARP, the National Council of La Raza, senior citizens groups like CARA, who's one of our sponsors, consumer advocates, legal aid organizations, all in support of this bill. I ask for your aye vote.
Thank you, Senator Leno. Witnesses in support?
Thank you. Yes, Elise?
Good afternoon. My name is...
Oh, good evening.
My name is Elise Stokes, and I am a staff attorney at Legal Services of Northern California. We are a legal aid agency that provides free civil legal assistance primarily to low-income people and seniors on a broad range of issues, including housing, health, and public benefits. We have a foreclosure prevention project in which we help low and moderate-income homeowners. I'm going to read a letter written by one of my clients that I've helped through this project who could not come to Sacramento today. Her name is Angie Depew. She writes, I write this letter in strong support of SB 1150. I am a widow who spent nearly 2 years struggling to keep my home. In 2012, my husband died and my life unraveled. His death hit me hard, and it was a very sad and difficult time for me. Adding to the difficulty, my income decreased significantly due to his death. We owned the home we lived in together, and I was able to make the mortgage payments for a while after his death. I eventually got behind on the payments due to the decrease in my income. It was then that I tried to call the loan servicer, City Mortgage, to ask for help. City refused to speak to me or give me information about the loan because even though I owned the home, only my husband was listed on the loan. I spent several months trying to get through to City on my own, and City representatives repeatedly told me that they would not talk to me because I was not the borrower. In September 2014, I contacted Legal Services of Northern California. Elise Stokes from Lisnick took my case and began helping me contact City. Even with Ms. Stokes' help, City initially continued to refuse to speak to me or her. I faxed documents to City showing that I was the sole owner of the home. City refused to acknowledge whether it had even received these documents. City continued to ask for documents to prove my ownership of my home that do not exist and are not necessary under California law. The loan on my home is owned by Fannie Mae, and I learned in this process that Fannie Mae has rules that require servicers to communicate with surviving family members in my situation and consider people like me for a loan modification and assumption. But even with these rules, it took months for City to even speak to me. In December 2014, Ms. Stokes sent City an application for a modification on my behalf. Even though the Fannie Mae rules required City to review this application, it initially refused to acknowledge or review the application. Ms. Stokes contacted multiple people at City and at Fannie Mae and spent hours over several months urging City to follow the Fannie Mae rules and review my application for a loan modification. Eventually, City did agree to review my application. But even after this, when Ms. Stokes or I would call City, we were often told by representatives that they could not speak to us because I was not the borrower, and they would not give us information about the status of my application. In October 2015, I was finally offered a trial modification that I was eligible for when I first applied in December 2014. I now have a permanent modification. While I am relieved that this ordeal is now over and I am no longer at risk of losing my home, I cannot begin to explain the level of confusion, frustration, and stress I felt over the nearly 2 years I was attempting to work with City.
Thank you. I've got to stop you here. It's getting late. You've gone on a little longer. I think you've made your point. Appreciate it. Next witness is no more than 2 minutes.
Okay. Thank you, Senator. My name is Mabel Elise Brown. I'm an attorney. I'm the Director of Housing and Economic Rights Advocates. We provide free legal services to people across the state of California on household financial issues from mortgages to student loans, et cetera. We work directly with the public, and we work with mortgage servicers as advocates, and similar to how Elise's program does. In terms of prevalence of the problem, we first got our early complaints in 2010. So my goal in my comments is to briefly emphasize this is a huge problem. We got our first complaints in 2010. We began to track the complaints around 2011, 2012, and brought in our partner, California Reinvestment Coalition, to engage in some advocacy. Well, actually, we reached out to industry first and negotiated with a very large mortgage servicer for some months to see if there couldn't be, we just couldn't believe that there couldn't be some sort of resolution to this. We couldn't believe that it couldn't be fixed. They told us that until Fannie Mae told them to do something about it, they would not. So CRC and HERA went to their Fannie and Freddie's regulator. We obtained further guidance from Fannie and Freddie on this issue, requiring contact with successors in interest. In 2013, in that same year, the Consumer Financial Protection Bureau issued a rule. We had also approached them, issued a rule saying, hey, servicers, you got to have a policy in-house that facilitates communication with survivors. I make a point about the year because it's now 2016, and we've gotten kicked off the year with almost 16 complaints at my office alone from survivors all over the state of California. I commend to you that there are reports, both statewide reports done by California Reinvestment Coalition in 2013, 2014, National Consejo de la Raza in 2015, National Housing Resource Center in 2016. There are national reports documenting the extent of the problem. So I will leave my comments at that.
Thank you very much. Any other witnesses in support, please, if you just step forward with your name, affiliation.
Good evening. Catherine Brandenburg, representing the County of Alameda in support.
Thank you.
Madam Chair, members, Deputy Attorney General Matt Campbell, the Attorney General Kamala Harris supports the bill. We thank the author and the sponsors for bringing it forward.
Thank you.
Good evening. Beverly Yu with UDW AFSCME Local 3930 in strong support. Thank you.
Thank you.
Madam Chair, Kevin Stein, California Reinvestment Coalition, a proud co-sponsor of the bill, and on behalf of Housing California as well, urge your support. Thank you.
Thank you very much.
Good evening, Norma Garcia, Consumers Union, strong support of the bill and urge your aye vote. Thank you.
Thank you.
Marjorie Murray, on behalf of the California Alliance for Retired Americans, one of the co-sponsors of the bill. Also, on behalf of the Center for California Homeowner Association Law, since about 1.5 million seniors live in common interest developments. Strong support.
Thank you very much.
Eileen Jacobs, I'm the Director of Litigation with California Rural Legal Assistance, Inc. We have many clients who suffer from this problem. They are disproportionately women and Spanish-speaking, and we think that this will provide a solution for them.
Thank you very much.
Judy Hunter, Rural Community Assistance Corporation supports.
Thank you.
I'm Jeannie Barrett. I'm now retired from California Rural Legal Assistance, but I was the director of the Rural Mortgage Prevention program there for a number of years. And we actually have one of our clients here to tell you her experience.
Thank you.
Sylvia Torres with California Rural Legal Assistance. I'm the Foreclosure Intervention Coordinator. Our clients would strongly benefit from this. It has been very hard to get help. We just settled an assumption and a modification. It took me 5 years to get that through.
Appreciate it.
Strongly support.
Hi, I'm Kimberly Pickens, and I'm a widow. I am thankful they're helping me. It's been a really hard road. My father given me the house, so I'm on the deed and I'm on the title, but I'm not on the loan. My husband passed away. The bank won't speak to me. They won't, it's nothing. I've sent death certificates and everything, and it's like, I am nobody, and it's my home. So please pass the bill.
Thank you very much.
Johanna Torres with California Rural Legal Assistance. Like she mentioned, we have clients where banks are telling them we're only going to speak to you if you give us money for the mortgage payment. Otherwise, we have nothing to speak to you. So this bill will really help a lot of our clients throughout California. We have offices throughout California, 20 offices. Thank you.
Thank you.
Kent Chan, the National Housing Law Project, in strong support.
Thank you very much. Any other witnesses in support? Witnesses in opposition?
Elise, we'll have to make room for the opposition. Stay here. Thank you very much. Thank you, and thank your client.
You get 2 witnesses, 2 minutes each. Good evening.
Thank you, Madam Chair. Kevin Gould with the California Bankers Association in opposition. We believe this measure is premature, and the reason why we would say that is that the Federal Consumer Financial Protection Bureau is promulgating regulations today. We expect that those regulations will be published in mid-2016. It's our understanding, as recently as some news articles in the past week and a half, that they in fact expect these regulations to be published in July. And from our vantage point, what we're asking for is that we have an opportunity to understand what those regulations ask us to do before we advance state legislation that might in some ways conflict, duplicate, or overlap. We've had a series of regulations that have come down from all levels of government on mortgage servicers that have made trying to figure out how to comply extraordinarily difficult. And that's having significant consequences, particularly on our smaller community banks who find it very challenging to decide whether or not they wish to enter into this marketplace. While we wait for CFPB to take action, there are protections in place. And we would just simply remind the committee, and I think the analysis has done an outstanding job of outlining some of those requirements, but there is federal requirements going back to 1982 under the Garn-St. Germain Act that prohibit a lender from accelerating a mortgage based on a due on sale clause if a relative is occupying the property. It allows them to continue to make mortgage payments, but it doesn't require them to accept the underlying debt. And in some cases, this may be a favorable outcome. There are policies and procedures in place that have been referenced in prior testimony for how you communicate and consider. And servicers will, when they get notification of the death of the obligor, discuss with the successor in interest whether they can pursue a loan modification, an assumption, or a name change under Garn-St. Germain. We have had successes, and there are circumstances where we can't help folks. And in many cases, it's because there's a diminution of income, and they can't afford the mortgage even under a modified term. So what we're asking for is an opportunity to see what those federal regulations look like. They're comprehensive. The proposal is 500 pages in length. There's been more than 160 comment letters issued by all kinds of stakeholders who are interested in the outcome. If there's a deficiency, if there's a gap, if there's some misalignment in the federal regulation, we would be more than willing to sit down with the proponents and see what more should be done. The private right of action in the measure is significant. For those reasons, we're opposed to the measure. We respectfully ask for your no vote.
Thank you. Briefly, sir.
Madam Chair, Pat Zenzala. I'm with KP Public Affairs, and I'm here on behalf of the California Mortgage Bankers Association, who opposed the bill. I'm going to just touch briefly on a few of the issues that we have with the bill. First, it creates a built-in delay in an already long and drawn-out pre-foreclosure and foreclosure process. That's important to understand because delinquency, it would actually increase delinquencies if payments are not being made. It makes it harder to cure a default and may lead to additional blight in communities if successors don't maintain the property. And remember, under the bill, there's no requirement for a successor to occupy the property, make a payment, or maintain the property. Second, the bill also makes it very clear that there can be multiple successors in interest, but provides no mechanism for the servicer to select the best successor. This is fraught with peril from a legal perspective for the servicer, given the private right of action, the significant penalties, the attorney's fees in the bill. It's also ripe for potential mischief or successor disagreements, and having had a parent recently pass away, I can tell you, beneficiaries and trustees don't always agree on what should be done with the estate. It's going to be used, I believe, as a way to leverage what can be done as far as allocation of the estate. As a practical reality, in order for a servicer to avoid the possibility of another successor claimant, under the terms of the bill, the servicer is likely going to file a quiet title action to establish the validity of the claim. Otherwise, even if the servicer allows one successor to assume and modify a loan, what's going to protect the servicer from competing successor claims? Finally, one of the bill provisions requires that if a successor or successors qualify for a foreclosure prevention alternative, the servicer must allow a successor to assume the loan. So under the bill, a servicer must allow one or more third parties, not part of the original mortgage contract, to assume the loan, even if the third party cannot afford the original mortgage, as long as they can qualify for an alternative that changes the terms of the mortgage contract. The negative and retroactive impact to freedom of contract and for what a contract between two parties means to me is breathtaking as far as changes.
Thank you
For those
very
reasons,
much.
we oppose the bill.
Thank you. Any other witnesses in opposition?
Valerie Nair for the California Chamber of Commerce. We are opposed.
Thank you.
Rodney Wilson with the California Credit Union League, also opposed.
Thank you very much.
Lexi Howard for the California Mortgage Association, opposed.
Thank you.